you, Mr. Shima. I will ask the council in 125-931, State of Kansas versus Cornell McNeal to please come forward. You may.
May it please the court, Caroline Zuschuk of the Kansas Capital Appeals and Conflicts Office, representing Cornell McNeal. If I may, I'd like to reserve 3 minutes for rebuttal.
It's granted. Thank you.
The crux of this appeal is that the jury that heard this case was improperly composed and instructed to fairly try a Black man. For that reason, I'm going to start by focusing on the opportunity this case presents to the court to protect an accused's fundamental right to a jury drawn from a fair cross-section of the community. And then I will proceed to other issues as this court requests. First, the district court denied Mr. McNeal his right to a veneer drawn from a fair cross-section of the community by retaining the veneer in this case, which contained at least 60 jurors, but not a single Black person. Counsel asked during voir dire if anyone in the room identified as Black, and no one did. Then the jury made some of the following observations. I'm surprised with Wichita representation that there aren't more Black people in this room, that there aren't Black people in this room. If I'm Mr. McNeal and I'm looking at this room seeing no one represents his peers, I'm uneasy. A math major said, if it's purely random, we should have, Black Americans in the jury. So I've been questioning that this whole time. Counsel moved to find a fair cross-section violation, and the court held the veneer was sufficiently diverse because it contained Hispanic jurors and said Mr. McNeal didn't prove systematic exclusion under Duren. It's important to start out by considering why we have the fair cross-section guarantee. The fair cross-section requirement is as fundamental to the jury trial guaranteed by the Sixth Amendment. The jury's purpose is to guard against the exercise of arbitrary power, to make available the common sense judgment of the community as a hedge against the overzealous or mistaken prosecutor, and in preference to the professional, perhaps overconditioned or biased responses of the judge. This prophylactic vehicle is not provided if the jury pool is only made up of special segments of the populace or if large distinctive groups are excluded. Moreover, it is not consistent with our democratic heritage, and jury diversity is critical to public confidence in the fairness of the criminal justice system. As a roadmap, Mr. McNeal did prove all 3 Duren factors, and if this court finds that he failed to prove the 3rd factor, which is the one most hotly disputed by the state, Mr. McNeal asked this court to revisit Duren under Kansas state law, or in the alternative, remand for a hearing on Duren's 3rd factor. The 3 Duren factors are well established. The first is that the party identifies a distinct and cognizable group. A racial minority is a distinct and cognizable group, and the state concedes as much. The second Duren factor requires the accused to prove that the representation in the veneer fell below what would be fair and reasonable in relation to the group's population within the whole community. There are typically 3 accepted measures of this disparity. Absolute disparity, which is the difference between the percentage in the population and on the veneer. Here, that would be a 9.3% difference because the Black population in Sedgwick County is 9.3%, and there were 0% Black individuals on the veneer.
Before we get into a statistical analysis, real quickly, I didn't see anywhere where you alleged or proved any kind of historical exclusion of Black Kansans by this judicial district. Am I right about that?
Yeah, there was not a historical overview in this case.
And there weren't any allegations or proof about any defects in the jury selection process?
Not other than that the process was used and it produced an unrepresentative veneer.
And so your factual basis is you looked around the room and there were no potential jurors who identified as Black.
Correct.
And in looking at the record, how do we determine whether there were any other ethnicities represented or minorities among the pool?
Well, first of all, because the state pointed out that there were, I think, 4 Hispanic men and 1 Hispanic woman. And that was not disputed on the record. So there were Hispanic minorities in the room, no other.
I mean, the notion is we're supposed to accept the statements of counsel during the voir dire process, and we don't have any findings from the district court about any of that, right?
You don't, which is partially why a remand would be useful. But also,
Isn't that your burden, though? And shouldn't defense counsel have gone to the process of trying to show underrepresentation based on some kind of systemic exclusion?
well, that's a twofold answer. First, he did show that there was exclusion of Black people from this particular veneer. And I concede that that wasn't done over a period of time. And whether there were other minorities on the panel is irrelevant to whether the methodology used excluded Black people. So it's irrelevant that there were Hispanic people on the jury. While that makes the jury more diverse, he's not alleging that there was systemic exclusion of Hispanic jurors, just Black jurors. So it's sort of irrelevant that there were other minorities on the panel because something can exclude one race and not another.
What was the mechanism of systemic exclusion that was proved from your perspective?
We're alleging res ipsa loquitur exclusion. Basically, but for some problem in the system, which was not specifically identified, this would not have happened by random chance.
Doesn't math cut against that argument? In
No.
other words, there is a statistical probability, which is low. I don't know what it is. Let's say
Less than 1/4% chance that this would happen randomly, and less than,
was that demonstrated anywhere?
I mean, that's what the math says. So that math was available to everyone at the
Okay.
district court.
My understanding was the state argued a different math, but maybe we can talk to the state about that.
Well, the state argued that there weren't 60 people in the veneer, which is why their math was different. But I think I refuted that in the reply brief, which is there were 60 people sitting like in these seats, and then there were additional people beyond, and your name only made it onto the jury list if you were called from the pool.
Well, let's
in the
just
back of the
say,
courtroom.
and I don't want to belabor this point too much, but let's just say it's 1% or whatever.
1/4%.
Okay, I'll even go with your 1/4%. That means 1 out of every 400 60-member panels will have no Black people, right? And isn't it true that in a big county like Wichita, over the course of several years, let's say, there's going to be 400 impaneled? I mean, so
It's not that it was.
is that systemic exclusion is what I'm asking, when the math suggests that just purely from a random draw, you're going to get these once every blue moon, let's just say.
I would say it's still a problem.
It might be, but is it systemic exclusion?
We argue that the probability is so slight, and especially if you combine it with the notion that you only have 9.3% of the population that's Black, and even assuming they comprise 1 out of every 4 jury trials, which would be an astronomically high amount, even knowing that Black defendants go to trial more often than white ones, it lowers that these two events would coincide, that there's a Black man on trial and no Black people in the veneer, becomes even more statistically unlikely. And I understand that there is a problem with the proof put down below. I think that the lack of Black jurors is enough to make an inference of discrimination under the 3rd factor. And I don't think the United States Supreme Court has held that statistics can be enough. In Norris v. Alabama, which was actually an equal protection case where you have to prove that the discrimination was purposeful, they said the exclusion of Black Alabamans from the jury over a period of time, which is another different factor, was sufficient alone to establish a prima facie case of an equal protection violation and to not only infer exclusion, but discrimination. So statistics can be enough. If this court has a problem with the proof set forward below, I think First, we need to discuss the fact that council could not have done more than they did. They asked to brief it, the court denied them that opportunity. They asked to argue it before the jury was selected, the court said no. They argued it after jury selection, the court denied it. In the 10 minutes in between making the objection and being called to argue it, the council could not have done the math. These statistics of veneers over time are not widely available. They're not published on the court website. I looked. He couldn't have just pulled them up and done the math and made the argument and subpoenaed all of these witnesses about how the jury selection was specifically done in this case, what list was called, whether there was a typo in Oracle. He could not have known to do that until he got there and saw that there were no black jurors on the veneer. And even if he had gone to search for the information, I'm not sure it would have been available, because the short juror form in Sedgwick County, which was linked in both of our briefs, I believe, doesn't ask what the person's race is. So until he showed up on the day of trial and saw that no one in the veneer was black, he couldn't have known he would needed to have mounted this problem. And while a regular practitioner in Sedgwick County might have noticed a trend of systematic exclusion, this case was tried by the death penalty defense unit, which only seldom practices in Wichita. So they wouldn't have had a number of cases over time to realize.
Can you help me understand the system or that Sedgwick County utilizes to acquire a jury pool?
Yes.
And so, because you mentioned there were 60, and I appreciate this, our courtrooms aren't built for massive amounts of people. So bring in a first group of 60 that are then exposed to the voir dire process. But you mentioned there were others. How many were, and did that group contain identified African Americans?
No.
The ones that are out in the hall, wherever they gather when they're
My understanding, and I haven't tried a case, well, ever, but not in Sedgwick County, is basically like there would be rows and then the jury box was filled with the people being questioned.
right.
And those are the names on the juror list. And the remaining seats would be filled with other people, but still in the courtroom. So when he asked if anyone identified as black, it was a question.
It was the first like 60 that were called in or something like that. But
Right,
were there others who were called for jury service for this?
No, everyone that was called for jury service was in the room when that question was asked.
Thank you.
Yeah. And then in terms of what Sedgwick County does, I remember the state cited it in its brief, but I believe they use driver's license, non-operator Kansas IDs, and voter registration. And they compile it off that. How they compile it off that, what they do. There's only been one case in the last decade that's found a Duren violation. And it was actually the state used an Oracle system. And there was just a typo in the parameter. We also use an Oracle system, but I don't know if that's how the jury is pooled. Obviously, if the case were remanded, these are things that defense counsel could put on and attempt to make a better Duren showing under the third factor. And while I acknowledge it's our burden, I think it's an impossible burden, especially under the circumstances in this case, and especially where defense counsel asked for time and was denied it. And especially where, if you read the record, defense counsel asked the court repeatedly if they could get information about the veneer prior to trial. And the court was like, no, that's not how we do it. We don't know who's going to show up. Like, we could give you these juror forms for the people that filled them out online. But even if, and they didn't do that, but even if they had, it still wouldn't have revealed the requisite information to lodge an appropriate challenge. But for this reason, more than remanding to put a Band-Aid on the problem in this case, I think it's imperative that this court revisit Duren under Kansas law. Duren was designed to protect this fundamental fair cross-section right, and as an experiment, it's utterly failed. Basically, every state to investigate whether their juries were representative of the communities in which they were drawn concluded that they weren't. That's Alaska, Florida, Minnesota, North Dakota, Ohio, Oregon, Michigan, Pennsylvania, South Dakota, Georgia, California, and New York. Couldn't find a specific judicial task force dedicated to that in Kansas, but I imagine the results would not be different. And that's because Duren is nearly impossible for a criminal accused to prove. And that's for a couple of reasons. One, in Kansas, as the state pointed out, in many jurisdictions, we don't know the composition of the veneer. prior to going into trial. So we can't possibly know that we're going to have to lodge this objection that then requires this onerous burden, evidentiary burden.
I don't understand that, because if there's a systemic problem down in Sedgwick County, it seems to me we'd have more of this, and it would be addressable. I mean, it really just seems like somebody walked into the courtroom, saw that no one was identifying as Black in the group, and now all of a sudden we have an issue, as opposed to there's a real problem in the way Sedgwick County pulls people out of the county to serve as jurors.
First of all, there have been other cases out of Sedgwick County, but not a ton. And I think that's because until any litigant shows up to court in Sedgwick County, they don't know the veneer. So in order to make a showing that,
But you know how they're selected.
yes,
And so what's wrong with the way they select them?
well, off the top of my head, Black people register to vote at a lower rate than white people. Black people are less likely to have driver's license, especially in lower socioeconomic brackets, which might include parts of Wichita.
And all of that would have to be demonstrated somehow. And again, if it's systemic, I
Right.
don't think you wait until you're right in the middle of things.
But you do all that work and then you get there and there's 10 Black people on the veneer. Like, you don't, just because it's a systemic problem doesn't necessarily mean, like, the reverse is true. Just because there's a systemic exclusion problem doesn't mean you won't show up and have an adequate jury. Like, the reverse, the probability is, so there's a really slight probability that this could have happened randomly, like very small. Well, there's also a probability that you could walk in and have a representative jury after having paid for all of those experts and done that work. And again, this was tried by a team of attorneys who doesn't regularly practice in Sedgwick. They wouldn't have had any knowledge that this practice would utterly fail to produce someone. Now, could the public defender system there launch a longer scale study? Yes, but again, the data would have to be available, and it's not. You can't find the data of the racial composition of veneers anywhere.
When you argue to us for a revisitation of Duren under state law, I think
Yes.
those are the words you used. What exactly do you mean by that?
I mean, the Duren test is what we use to evaluate a Sixth Amendment violation. And I think that we could apply a different standard in Kansas.
We couldn't under the Sixth Amendment, could we?
No, but you could under the Kansas Constitution, or you could under Kansas statutes.
What is that test that you want us to apply?
Okay, well, different alternatives exist, any of which would be better. And I would point out that Iowa already applies a different test under Duren. It roughly follows the Duren framework, but allows different proof. And Washington has considered it, but denied it, because in that case, they require you to explain why the state constitution requires a different analysis. And I don't believe that Kansas has that same requirement. And even if it did, we have a statute in Kansas that codifies the right to a fair trial by an impartial jury randomly selected from peers. So there's a
Does
statutory.
that provision differ from the federal constitutional requirements? And my problem is, in your brief, you say, oh, there's a textual difference, but no authority to back it up, or no historical background to say that this provision was to be interpreted at the time differently than the federal constitution.
I'm not asserting that there is a textual difference in our constitution. Obviously the jury trial rights inviolate there's no federal analog. Like, there are textual differences, but the reason I think that this court should apply a different standard isn't because of a difference in the text. It's because this court has the power and authority to redress the wrong that Duren was designed to redress for Kansans. You may not be able to make that difference nationwide, but there's no real dispute that Duren fails to protect the fair cross-section rights, and that litigants can't surmount that burden, and that people like Mr. McNeal, who are Black, are forced to go to a trial when no Black people are on the veneer.
It sounds like you're saying we should just exercise our general administrative authority over courts in Kansas to make a rule.
Yes, and we also have this Kansas statute. Like many jurisdictions don't have a statute that,
But as I understood your answer to Justice Biles, the statute is essentially the same as what is protected under the Sixth Amendment.
yes, but we've given it a specific codification in Kansas. Like the language of our statute mirrors the right allegedly protected by the Sixth Amendment, but we know Duren isn't actually protecting that right. And therefore, as judges in Kansas, you can say, because the fair cross-section right is fundamental in Kansas, and because our legislature has chosen to elevate it to not just an implicit guarantee, but a codified statute, we're going to apply a test that litigants can actually achieve to, not in every case, obviously, but a burden that actually works to protect the diversity of juries to reflect a fair cross-section.
Okay, so you were going to talk about what you believe. Someone asked the question of.
Oh, yeah, sorry. What are the other options? So a couple of different tests exist. First, if a party arrives and there's no minority representation of a particular minority, and particularly if that person is of that minority, for example, in Mr. McNeal's case, the court could simply ask if the defendant wants to continue trial and dismiss the veneer. And the defendant, if he wanted to continue to trial, could then waive his right to a fair cross-section. And if the next veneer came back with no representation, then the state would bear the burden of showing that it wasn't systematic exclusion of a particular racial group.
How might a test like that work in other parts of our state that maybe aren't metropolitan and the demographically are significantly different?
Yeah, I think it would be harder in those. So perhaps that's not the absolute best test, just because if you only have 1% African-American, it's pretty likely you're going to get a jury that doesn't have any African-Americans on it. So that would be a better test for places like Sedgwick. At the same time, I don't think it's impossible, like even, yeah, I would agree with you. That would be harder in counties where the diversity is even lower. I think a res ipsa or employment discrimination model would be effective, where there's burden shifting. Once a disparity is shown under the second factor, the burden shifts to the state to show that the methods they use did not systematically exclude someone. Keeping in mind, no intent is required. We're not alleging that Sedgwick County necessarily purposefully excluded anyone, or that the state would have to demonstrate that they didn't do it on purpose, just that some selection method is keeping Black Kansans from serving on juries, and that in order to redress that, we have to have a test that people can actually use. Further, the accused could make a prima facie case under Duren about his own veneer, at least under the first two factors, and even under the third, if that data were published weekly and available in every court, so you could pull it up when you come and see that that's what's happening. And since the accused's own veneer is the only one about which he has statistics, he makes a showing under the first two factors, and then the burden shifts to the state to show that veneers are not generally unrepresentative, though of course the state would need data to do that as well. Or you could maintain the Duren test, but only in jurisdictions who make their veneer data publicly available and published.
Let me ask a question. Why is this something that falls under the judicial branch instead of the legislative branch? So, for example, you know, the underlying reasons that you gave where it wouldn't be intentional, but it would have a disparate impact, to use employment terms, is that, you know, the driver's license or voting registration. Why isn't this something that the legislature should address, especially given that there's a statute about it?
Well, that's twofold. First of all, the fair cross-section requirement, other than that it is statutory in Kansas, has always been handled by the courts. The Duren test isn't a legislative test. So you're the ones who have the ability to change that. Whether the legislature should change the lists it approves and condones is probably true as well, but I highly doubt it will do so unless there's a finding by some court in the state that perhaps those things are not representative in the way that they should be. I think the problem that we're dealing with is from the point that the veneers are being chosen, the population has already been reduced. And that's what the Iowa courts have suggested. In State v. Lilly, they found that that you can challenge these sort of routine practices and, for example, the lists through which things are compiled. And I see that I am out of time, but I'm happy to answer further questions as needed. Thank you so much.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I have read the defendant's brief, I have read the defendant's reply brief, and I have listened to the argument today. I have yet to hear the defense at any point express any arguments with respect to the system by which Sedgwick County selects their jurors and how that has been a problem.
Well, the defense counsel did raise the restriction on the pool of available jurors through the mechanisms of voter ID, voter registration, identification cards, and driver's licenses. Would you agree that those are the mechanisms used to create the total pool of available jurors in Sedgwick County?
Yeah, and I cited that in my brief, and this court has approved of
sure, but entertain at least with me the discussion.
Sure.
Why isn't it at least a reasonable argument by the defendant to claim that that mechanism impermissibly narrows the scope of available jurors from every adult citizen of Sedgwick County to some smaller subset?
Because there's a difference between the system discriminating and people, for lack of a better phrase, removing themselves from the system.
Is that true? Does the state not have? So for example, and I know this is a total hypothetical, but let's just assume that there was evidence in the record that the total number of Black Kansans within the Sedgwick County jury pool in total was 4%, whereas the total number of residents was 9%. Would that be a problem?
I would argue no, if it's not the system itself.
But it is the system, right? The system is narrowing the scope of available jurors.
The system would not be narrowing it down. There would be nothing preventing Black citizens from doing the things that, from registering to vote to getting a driver's license.
You're saying it's the citizens themselves that are essentially excluding themselves.
And I think that's consistent. I think the case law, there have been cases where it talks about in some situations, there might have been an equal number, or the percentages might be consistent with the percentage of the population as far as who receives the jury summonses. But then certain segments of the population or subsets of the population might simply choose not to show up at court. I know in some of the cases I read as I was researching this issue, the case law talked about that if you send out the jury summons and let's say 50% of the African-American jurors or potential jurors who receive the summons simply choose not to report to court, whereas only 20% of the white jurors choose not to report to court. Yes, there will be a difference in the percentage of whites and Blacks who end up coming to court. But again, that has nothing to do with the system. And I would argue it's the same thing if we're talking about the system would not be unfair. There's no greater barriers to African Americans getting driver's license or registering to vote than there would be to white citizens.
What if you don't want to vote and you can't own a car? I don't understand your argument.
Well, I
So
think
now it's the burden on the population
I think
to
that
qualify themselves as jurors?
I think in Sedgwick County, it's driver's license or state issued ID cards. So it's not just driver's license.
I was just listening to your argument.
Well, I did brief that in the brief, I did make clear that it's driver's license or other state issued identifications.
So, but aren't you just proving counsel's point that you said if you send out the jury, if they're not showing up because you send out the jury summons and they choose not to show up, then, you know, they're excluding themselves. But isn't her point that there is no statistical information, there's no data out there to tell us what's going on?
Well, I would point to the fact that in some of the cases that have addressed this issue, there have been attempts, and the defense there has been research. Their numbers are in some of those cases talking about in a particular county. I think I think 2 or 3 of the cases that have addressed this issue were from the same county in Western Kansas. I can't remember if it was.
But if those counties are making that information public, but Sedgwick isn't, I mean, isn't that her point?
Well, again, it's their burden. They're the ones trying to argue that there is a systemic problem. And while she's correct that at the time of trial, they made a general objection to this, at no point did they attempt to present the historical data. And they had the opportunity. I agree with her.
They have the opportunity when they had 5 minutes and they denied
They didn't have 5 minutes. They had several weeks between the end of trial and sentencing, and they filed a motion for new trial, and it was as boilerplate as it gets. It raised nothing more than the lip service objection that they raised in trial. And at the sentencing hearing, when asked to address it, he said nothing beyond what's in the motion. So not only did they not present anything, they didn't say, we need a continuance of sentencing because we'd like further time to try and figure out whether this information is available. They've never argued at the district court level that the statistics weren't available.
I thought I understood opposing counsel to say that there was a request for some time.
That was at the trial. I think at the initial objection that they had made on the day of trial.
Okay.
But then, and so if that were the only issue, perhaps I would credit that argument more. But when you then have a trial that lasts several days, and then you know that you've got several weeks before sentencing, and that you're wanting to pursue this issue, and that you're going to include it in your motion for new trial, I think at that point it's incumbent, and it's not unfair to think that at that point there should be a burden as the party who is trying to assert an error. And I just can't escape the fact here that all they're pointing to, and I think Justice Stiegel hit on this, all they're pointing to is the statistics. And I won't belabor the issue of whether it's 60 or 52. I'll concede for the purpose of this argument that the number is 60 and that her math is correct then. And that means that it was about a 1 in 400 chance that this would happen. That does mean statistically, once every few years, this will happen in Sedgwick County. We have a lot of trials in Sedgwick County. And 1 in 400, it's not often, but it's not never. And statistics can be used in all sorts of ways, and people can be surprised. And yes, it's obviously, if you're walking into this jury trial or this voir dire process, you're not going to expect this to be the outcome, but it will happen occasionally. And that's not a systemic problem. I don't know how many of you are sports fans. 2 nights ago, the NBA had their big draft lottery. The team that ended up getting the first pick had a slightly over, I believe it was a 1.8% chance to win the draft lottery. That's the way the ping pong balls or the computer generated numbers fell. Nobody is asserting that that was a systemic problem. It's unfortunate if you're one of the teams who had a 14% chance to win the draft lottery. And if you're the team that did win it with a 1.8% chance, you should probably go buy a real lottery ticket. But again, nobody is saying it's a systemic problem other than the crazy conspiracy theorists who always are going to come up with something for that. But 1 in 400, if you were told that you were getting on a flight and that there was a 1 in 400 chance that the plane was going to crash, would you think to yourself, well, that's just so outlandish, it's never going to happen, so I'm still going to get on this flight? I'm certainly not here suggesting that it's not desirable. Nobody's disputing the goal that Duren and the case law has. We all want fair cross sections represented. But the question is then, can a defendant succeed by simply saying, well, my particular time, I happen to be the one guy out of 400 where the statistical anomaly happened. That can't be enough. And that's why the Duren test has the 3 steps. And the defense in their brief very clearly is trying to, if not merge the second and third factors, they're trying to ask you to read the third factor out entirely and say that numbers alone can be enough.
Would you agree that if there was a showing in a hypothetical case that this scenario happens more than 1 out of every 400 times in Sedgwick County, that that's probably enough?
I think if there was a showing that of a historical anomaly that rises to a level of statistical significance, I mean, what would that be? Would it be, if it's supposed to be 1 in 400, would I concede that it would be a problem if it turns out to happen once every 320? Probably not. But if it rises to the level of statistical significance on a historical basis, then I think, yes, that would go a long way towards proving.
And that's essentially the cases that find Duren violations.
Correct.
That's the type of evidence that was produced.
Right.
Is that right?
Yes. And I think here what we have, counsel, I think as kind of their backup argument, perhaps recognizing that they can't meet the third prong, is this request that this court revisit Duren under state law. And I would say 2 things to that. First of all, she's admitted that there is no textual difference that would support that different interpretation. But second of all, I think that the bigger issue I have with it is that this is the textbook example of a solution looking for a problem. If they had shown, to your point, if they had shown some historical evidence in Sedgwick County or Kansas as a whole, that this was happening more often than should be expected, not just that Cornell McNeal walked into trial one day and he happened to be the 1 in 400, but this was happening historically on a level that would make you think, okay, there is something wrong here with the process, then it would at least be reasonable, I think, to say, maybe we need to reconsider this or try and figure out if in Kansas we want to do something a little bit different here to make sure that this doesn't continue happening at a pace that is too frequent. But they haven't made that showing. Again.
To that end, though, and I know, this isn't part of the record, but in your opinion, how should they go about getting this data?
I can't answer that because I don't know what efforts they've made to do that.
No, what effort would you make?
I would start by obviously looking at trying to get any records I can, whether it's from a publicly available website or going to the clerk's office, going to the courthouse and trying to find that information. How I would do it, I would literally walk up to the 6th floor and I would say, hi, I'm Matt Maloney with the DA's office. Are there records available on Sedgwick County jury pools?
Okay, and hypothetically, what if the answer is no, not available to the public?
I would find out whether that information is available to licensed attorneys. I would find out whether there was some other way to go about it. There's all sorts of steps that you could take, but it's difficult for me to answer that question because I'm not the one making the argument, and I'm not the one who failed to show below that information is not available.
In the motion for new trial.
Excuse me?
And you're just focusing on the motion for new trial.
That or yeah, sure, or at any point during the proceeding. But that's the point where I feel like they certainly had the most time to try and explore this issue. And I think when you look at the objection, even at the trial phase, that the defense attorney made, he more or less, it's in my brief, I can't remember the exact wording off the top of my head, but he more or less acknowledged that I'm making this objection and I do want to preserve it. And he did ask for some additional time, but he also conceded that he, at that point, could not prove any historical or systemic issues. And so to me, if I'm litigating the issue right there, in addition to asking for additional time, that would be what I think it would be incumbent upon me to start trying to find that information. If you're a defense attorney in that situation, I mean, I realize during trial, you're not going to have unlimited time to do that type of thing. But if you've got somebody else on your team who could start trying to go to the clerk's office but again, certainly in the 6 or however many weeks it was between conviction and sentencing. And again, I'd urge you to look at the transcript of sentencing. When asked to argue the issues in the motion for new trial, he stood on the written motion, which to my recollection was essentially 1 or 2 very short paragraphs where it just recited the fact that there were no African Americans in this veneer pool. I don't think that's enough. And I don't think that this is a situation where it should be remanded to give them a shot to do something that they didn't even attempt to do below. If they had asked the court for a continuance of sentencing, or if they had said, Judge, we've spent the last few weeks trying to get access to this information, and we've been stonewalled at every turn, and it is impossible for us to get access to this information, then again, we're in a totally different situation at that point, and I could possibly agree that maybe a remand is necessary. But standing here today, I don't know for certain whether it is or is not possible to get that information from Sedgwick County. I don't know the answer to that question. So I don't think we should just assume that that's the case when there's been no showing of that below. But again, when you boil this down to me, you have a situation where, as I conceded, yes, we all agree that it's a laudable goal and you want to have diversity in your jury panels, but there's no surefire way that you can make that happen 100% of the time. There are always going to be statistical outliers. Unless something is truly 100% certainty, there will be, whether it turns out to be in some counties, because of a lack of diversity in the citizenship as a whole, that might be a 1 in 50 chance. In Sedgwick County, it might be 1 in 400. In Johnson County, it might be 1 in 600. But no matter how big your jurisdiction is, it will happen occasionally. And that's why it's important to look at the reasons behind it.
I guess I didn't mean to cut you off,
You're
but I understand our precedent, and I understand the focus on systemic process. But at the end of the day, if you're sitting in Mr. McNeal's shoes, does it really even matter? I mean, his experience and realization of his jury trial right is what it is, regardless of whatever path got him there. And in the sense of a larger sense of fairness and justice, is that acceptable? I understand our precedent, but in considering whether we need to re-examine things, I understand that there are statistical anomalies, but is it right to just accept that?
My answer would be that I think the purpose of the legal system, especially the purpose of the appellate system, is to correct errors. To review the record, see whether the process was fair. Even in the context of trials, the case law has used the phrase for decades that defendants are entitled to fair trials, not perfect ones. And so I would say that while I would obviously sympathize with a defendant in his position, but when there's no showing that an error led to that result, I do think it matters. I do think that there has to be some showing that something went wrong other than just a statistical fluke. And council proposed the one system where, well, if there's not an African American in the panel, then you just automatically dismiss that panel and you start over. And if it happens again, then the burden's on the state. I would again submit, I think that this is a solution looking for a problem. Unless we see additional, and I can't remember which one of your honors pointed it out. I believe it was Justice Biles. If this were truly a systemic problem, given the volume of trials coming out of Sedgwick County, it just defies logic to think that we would not have seen this issue more and more. I mean, I have never seen it raised before. Doing the research, as I said, I found a couple of cases from Western Kansas where the defense had at least tried to present some historical data. And I think in both of those cases, or maybe it was 3 of those cases, it was the same defense attorney trying the cases in the same county, and all of the arguments failed.
Counsel, if I may, I know I'm interrupting you, but you're out of time, and I want to just ask a couple questions, if I may. First, would you acknowledge that the right to a fair cross-section applies regardless of the distinctive characteristics of the defendant?
Yes.
So it doesn't matter whether the defendant's African American, Hispanic, white, whatever.
Correct.
And then with respect to I want to explore a little bit the scope of the Duren rule, the first prong in particular. Like, are Presbyterians a distinctive group?
That's
or Muslims, or any other. I mean, we have groups that have historically been discriminated against,
right,
obviously, and that's what rises to the top of the general concern. But just looking at the rule, I'm just trying to explore could someone make a Duren challenge saying there weren't enough Presbyterians on the jury?
Right. No, it's an excellent question. And I don't think the case law has certainly fleshed out an exhaustive list of what constitutes a distinctive group for purposes of this. And I might be wrong about this, I think maybe race and gender have been mentioned. I don't know that it's even been extended to age. I feel like my research tended to indicate that maybe age
or net worth, let's just say.
Exactly.
I have to have a certain number of millionaires on my jury.
Right. So that is in this case, clearly I'm not challenging the fact that African Americans qualify as a distinct group, but I do think that that's another.
I'm just thinking in terms of if we revisit Duren, as the defense has argued, I'm trying to think through the consequences of that.
Exactly. It's definitely not a straightforward issue, because to your point, there are all sorts of groups that somebody could point to and say, yeah, whether it's religion, some other identifying characteristic, gender identity. There's all sorts of things that one could point to. And yeah, at some point it would be logistically extremely difficult to get to a point where you could assure that even that you could even satisfy that first prong there. So again, I think that's another reason to be cautious when entertaining the request to revisit a well-established United States Supreme Court test in the absence of compelling, or I would say any evidence that is needed in a situation like this. Again, absent any proof that there is a problem, and when the 2 methods that Sedgwick County uses to select its jury pool have both been approved by this court. So I realize I am well past time, and I appreciate all the questions on it, because again, I recognize it's an important issue, and nobody from the state is going to get up here and suggest that it's not, and that Duren doesn't have a laudable goal here. But Again, our position would be quite simply that this is something where they are essentially trying to rely on numbers alone. And none of the case law supports that you can use that for the third factor. Even the case that she cited from the lectern today was one where she said it was one where they used numbers, but they used it from a historical perspective. And here, that's what we are critically lacking. We're looking at a sample size of one trial in this case. And you can't use statistics when your sample size is one. So our position is that no error occurred in this case, and we would respectfully request that this court affirm the defendant's convictions.
Thank you.
Thank you.
You reserve 3 minutes.
Can I real quickly get you to address my last questions, which is number one, would you agree that the fair cross section right attaches regardless of the characteristics of the defendant?
May it please the court? Yes, absolutely.
And then what do you think about my question about how under Duren, how do we evaluate distinctive groups? Does a religious
It hasn't succeeded.
there's been case law where people have tried that?
Well, in the death qualification context, I think there's been like religious opposition to the death penalty was not considered a distinct class. I'm not sure if like specific religions have tried it, but I know age has failed, like the state said, socioeconomic has failed, like poverty. The only ones I know of succeeding are race, and the only ones I know.
Fair cross section right does not apply to religious affiliation? Is that?
I have not read a case where it applied.
Does it seem right to you that the fair cross section right would not apply to religious affiliation?
No, it does not seem right to me, but nothing about Duren seems right to me, and that's why I'm here.
Where in the record, I'm somewhat frustrated, I guess. So it's a known fact going into trial, publicly available, from what I can see from the briefs, how Sedgwick County picks their jurors, what the pool is consist of.
Yes.
They say, this is what we're going to do.
Yes.
And no one before trial came in and said, that is a systemic exclusion of African Americans.
No.
And on the motion for acquittal, no one came in and made that argument. And on the motion for sentencing, which I have in front of me, it's literally one line.
Yep.
How does that represent the building of a record that allows us to do what you want us to do?
Okay, well, I think the answer to that is sort of threefold. The information is not publicly available. It's debatably not.
They ask, where in the record does counsel say, I've been trying to get this, I want the court to order that I get this stuff so that I can show a systemic exclusion?
Okay, well, if counsel failed and should have done more, then I'd like to request a Van Cleave. I mean, if this wasn't sufficient, these are some of our best trial attorneys in the state. It's not possible to imagine every possible scenario that can
But you
appear
don't
in
have
any
to
given.
imagine at the post-trial stage,
Okay, but what?
because you know what you got.
Okay, but what
You know, you
difference would
walked
it?
into a room and you didn't have anyone identifying as African American.
Should they have done more? Yes. But what they did do, I think, is sufficient for this court to do what I'm asking. First of all, we know the data isn't publicly available. We also know that the short form juror questionnaire doesn't ask people about race.
How do we know that? How do
Because
we
it's-
know that the voter registration information is not available?
We don't know that the voter registration information is
That's one of
not
the
available.
criteria.
Pardon?
That's one of the criteria.
Yes, Your Honor.
Okay, I
Does
mean,
voter registration have race on it?
I actually don't even know. I meant we don't know who's appearing for the juries. So we don't know that. How could they have known that there might be a systemic problem in Sedgwick County prior to showing up and being the 1 in 400?
But even if that's true, they know it after the fact and they don't do anything.
I'm not sure without data on the veneers available that there's anything that briefing it would have made any difference. Their brief would have looked exactly like mine. I looked for all of this data and I couldn't find it.
No one asked the court to get it. No one asked the court to be able to argue this.
We don't know.
Just this, well, I can read the motion. I got it right in front of me. That's the frustration here. You know, no one says this isn't an important issue, but a record has to be built so that an appellate court can deal with it.
And I'm saying without publicly available data, it's nearly impossible to build that record. And that's why Duren should be revisited. If we all want a fair cross-section, and the state arguably said that they did, how do we make that happen? It's not through Duren. And I'm not asking the court just to look at this one unrepresentative veneer and say, oh, well, because this happened one time, we should revisit the state law. I'm asking it to look at all of the articles I cited, all of those state studies that looked at jury pools and said they're not representative. I mean, scholars have described Duren and the fair cross-section guarantee as illusory, woefully inadequate in practice. And that's after reviewing every case ever discussing this.
Were those authorities given to the district court to look at?
No, but the district court was duty bound to follow Duren and this court's precedent, which applied Duren. This court is the one that has the ability to change the test that we apply for Kansans. The fair cross-section right is not aspirational. It's a fundamental right that people have when they walk into a courtroom. And despite the efforts of counsel here, which maybe could have been greater after the case had already been decided by this jury, but despite the efforts that they made, this data isn't readily available. They couldn't have prepped the experts going in. The problem was that they would have needed a record on like which specific lists and how it was entered in Oracle. And they couldn't have known to subpoena all of the people who have control over that. The computer person who probably isn't even in Kansas, who does the randomization, if indeed they use a computer system in Sedgwick. That record should have been made, but they wouldn't have known they needed to make it and they weren't given time to make it. Their brief would have ended up much the same as mine. And I did the absolute best I could to try and bring this issue to the court because it is important. And I think the record is sufficient to show all of the challenges litigants face when they want to argue that their jury isn't representative. This was a capital murder trial. Mr. McNeal, while the race of the accused does not matter, this was his particular peers were not represented. While everyone has a right to a diverse jury, and while diverse juries benefit everyone, it's particularly useful when there is a Black defendant. And that is because you put one Black person on the jury and the rate at which Black people are convicted is equalized with white people at around 71 to 73%. If you have an all-white jury, Black people are significantly and statistically more likely to be convicted. It's like 80 versus 60% for white accuseds. So it particularly prejudiced him that there were no Black people on the jury. And particularly, we're not talking about a rural area in this case. We're talking about a fairly substantial population. And I use 9.3% as the number, but that ignores anyone that's biracial because I couldn't parse those statistics out because despite searching for days, I was unable to find a breakdown of the biracial identifications and whether any of those people would also have identified as Black. When the state was arguing, it also noted that the citizens choosing to remove themselves from the process doesn't mean that it's a systemic problem. And I would just respectfully disagree. It's the court's job to ensure that the jury, the veneer is drawn from a fair cross-section. And if the court is relying on methods which some people select at higher rates than others, then the system is deselecting jurors, not the individuals. Moreover, while that might matter in an equal protection situation where the right belongs to the juror who has the right to serve, here the right to a fair cross-section is Mr. McNeal's. It's not the citizen's right.
Do you think that if you had evidence, and I asked this question to the state, do you think if there was evidence in this record that, a very simple evidence, that the percentage of African Americans in the subset of Sedgwick County residents who have a driver's license or an ID or registered to vote is statistically significantly less than 9%. I think I threw out 4%. Do you think that's enough? Just that evidence, would that be enough to prove systemic exclusion?
Yes.
And wouldn't that data be much more readily available than the sort of data we're talking about what do the jury veneer pools look like in Sedgwick County and so on? I mean, that seems to me
That would be more available.
something an
but
expert could.
an expert would have needed to have been called to do that.
But that doesn't strike me as it's not a stretch to imagine an expert testifying, yeah, I have the data. I can tell you that the subset of Sedgwick County residents who have one of these three forms of identification is 5% African American. The general population is 9%. That's.
Yeah, I mean, if they'd been given time to get that expert, then I think that would have been appropriate. I think if the court here had given a chance to brief it and they had still come back with nothing more than what we've already shown, then we'd be in a different situation. But they asked for that time, and that they didn't do it at sentencing after the trial had already happened when they weren't given a chance to make the record or have a hearing on it. I'm not sure the result would have been any different. Duren was a case where women opted out of jury service, and it was still a systemic problem. Even if Black people are registering to vote less or getting driver's license at a lower rate in Sedgwick County, that's still a systemic problem. But the real problem is that Duren doesn't protect the right to a fair cross-section. It's been shown nationwide. Every study to look at it has said that it's failed. And this court has the opportunity to craft a better test to use in Kansas and to craft a better test to protect that right. And for those reasons and the other reasons that we asserted in our brief, we respectfully request that you reverse Mr. McNeal's conviction and remand his case for a jury trial in front of a jury composed from a veneer that is based on a fair cross-section of the Sedgwick County population.
Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.